Hello, I am Reiner Fuellmich and I have been admitted to the bar in Germany and in California for 26 years. Let's first take a look at the unconstitutionality of the measures. A number of German law professors, including Professors Kingrain, Morswig, Jungblut, and Vosgerau, have stated either in written expert opinions or in interviews, in line with the serious doubts expressed by the former president of the Federal Constitutional Court with respect to the constitutionality of the corona measures, that these measures, the corona measures, are without a sufficient factual basis and also without a sufficient legal basis, and are therefore unconstitutional and must be repealed immediately. Very recently, a judge, Thorsten Schleif is his name, declared publicly that the German judiciary, just like the general public, has been so panic-stricken that it was no longer able to administer justice properly. He says that the courts of law, and I quote, have all too quickly waved through coercive measures which for millions of people all over Germany represent massive suspensions of their constitutional rights. He points out that German citizens, again I quote, are currently experiencing the most serious encroachment on their constitutional rights since the founding of the Federal Republic of Germany in 1949. In order to contain the corona pandemic, federal and state governments have intervened, he says, massively and in part threatening the very existence of the country, as it is guaranteed by the constitutional rights of the people. What about fraud, intentional infliction of damage, and crimes against humanity? Based on the rules of criminal law, asserting false facts concerning the PCR tests or intentional misrepresentation, as it was committed by Messrs. Drosten and Wheeler as well as the WHO, can only be assessed as fraud. Based on the rules of civil tort law, this translates into intentional infliction of damage. The German professor of civil law, Martin Schwab, supports this finding in public interviews. In a comprehensive legal opinion of around 180 pages, he has familiarized himself with the subject matter like no other legal scholar has done thus far, and in particular has provided a detailed account of the complete failure of the mainstream media to report on the true facts of this so-called pandemic. Messrs. Drosten, Wheeler, and Tedros of the WHO all knew, based on their own expertise or the expertise of their institutions, that the PCR tests cannot provide any information about infections, but asserted over and over again to the general public that they can, with their counterparts all over the world repeating this. And they all knew and accepted that on the basis of their recommendations, the governments of the world would decide on lockdowns, the rules for social distancing, and mandatory wearing of masks, the latter representing a very serious health hazard, as more and more independent studies and expert statements show. Under the rules of civil tort law, all those who have been harmed by these PCR test-induced lockdowns are entitled to receive full compensation for their losses. In particular, there is a duty to compensate, that is, a duty to pay damages for the loss of profits suffered by companies and self-employed persons as a result of the lockdown and other measures. In the meantime, however, the anti-corona measures have caused and continue to cause such devastating damage to the world's population's health and economy that the crimes committed by Messrs. Drosten, Wheeler, and the WHO must be legally qualified as actual crimes against humanity, as defined in Section 7 of the International Criminal Code.